there, my name's Ian Lovett and I am the Head of Mediation at Mediate UK Limited. I'm going to talk to you today about Tolata. Tolata stands for the Trust of Land and Appointment of Trustees Act. And that act relates to people who have cohabited, their relationship is over, and they now want to split their assets. And Tolata covers jointly held assets. It doesn't cover assets that one individual holds that they might wish to share with the second individual. When it comes to property, if your house is owned by one of you, then the second party may well be able to claim a beneficial interest in that property, and therefore that affects the process that you go through in mediation. If you obtain your TR1 from the land registry, your TR1 will tell you how you own the property, whether it is joint tenancy, whether it is tenants in common. If tenants in common, is it equal shares or unequal shares? All of this is really important to know. Once you've got that, then you can go and get legal advice, and that can be really valuable in Tolata cases to get that legal advice early to understand the position that you're in. Tolata cases, if they go into court, usually are governed by a strict application of the law by the court. So if the property is owned by one person, it's unlikely, and I'm not giving legal advice here, I'm just sharing knowledge with you, it's unlikely the court's going to change that. But the second party then may have a beneficial interest if they have been contributing to bills, the mortgage, etc. And it's then a negotiation around that beneficial interest. First stage of mediation, disclosure. So you have to disclose all jointly held assets, property, and have that valued. And then it's a discussion between the two of you about how to try to move that forward. And that could include one buying the other out. It could include selling the property. It doesn't often, but it could include renting the property out and taking an income from it. But there are options there for you both to consider. Mediation process, probably 2 or 3 joint meetings to get you to a conclusion on average, depending upon how complex the two of you make this process. And I don't mean that in a derogatory sense. What you have done and how you have done it is going to inform how you now apply this process. That may mean that one of you wants to claim for various things that have been done in the property. You might have funded a new kitchen, you might have funded a new bathroom, and you feel that you should get some recompense for that. That's what we're talking about, beneficial interest. If you have been contributing to the mortgage for the last 4 or 5 years, there may be a beneficial interest claim there too. Complex area of law, get that legal advice. No reason why you shouldn't be able to agree something within the mediation process. And I hope that's helpful. Thank you for your time. Bye-bye.